Will the House please come to order and members kindly take their seats? Good afternoon. In lieu of a devotional today, will you please join me in a moment of silence? Members, we have 18 House bills for introduction today. With that, member from Poultney, can you please offer us a motion to suspend our rules to introduce bills by number only?
Madam Speaker, I make a motion to suspend rules in order to introduce bills by number only.
The member from Poultney moves that we suspend our rules to introduce bills by number only. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to introduce bills by number only. Please listen to the first reading of bills by number only.
H 870.
To General and Housing.
H 871.
To Commerce and Economic Development.
H 872.
To Judiciary.
H 873.
To Judiciary.
H 874.
To General and Housing.
H 875.
To Judiciary.
H 876.
To Judiciary.
H 877.
To Commerce and Economic Development.
H 878.
To Ways and Means.
H 879.
To Environment.
H 880.
To Judiciary.
H 881.
To Government Operations and Military Affairs.
H 882.
To Environment.
H 883.
To Environment.
H 884.
To Government Operations and Military Affairs.
H 885.
To Human Services.
H 886.
To Ways and Means.
And H 887.
To General and Housing. Members, we have a bill on the notice calendar requiring referral to a money committee pursuant to House Rule 35A. House Bill 647 is an act relating to the creation of the Vermont Sister State Program. Carrying an appropriation, the bill is referred to the Committee on Appropriations. Members, we have 4 resolutions to take up at this time. The first is a House resolution for introduction. H.R. 13 is a House resolution relating to the end of apartheid and support for the people of Palestine and Israel in the resolution of conflict, offered by Representative Chena of Burlington and others. Please listen to the resolution by title only.
H.R. 13, House Resolution relating to the end of apartheid and support for the people of Palestine and Israel in the resolution of conflict.
Now the resolution has been read for the first time, and the same is treated as a bill and referred to the Committee on Government Operations and Military Affairs pursuant to House Rule 52. We also have a joint House resolution for introduction. JRH 8 is a joint resolution condemning the January 3rd, 2026 U.S. military incursion in Venezuela and imploring that Venezuelan President Nicolas Maduro and his wife Celia Flores be released from U.S. custody, and that all U.S. military forces recently deployed in the Caribbean Sea and the Eastern Pacific Ocean be withdrawn immediately, that Venezuelans be allowed to exercise their right to political self-determination on their own accord, and that the United States abandon any intentions or plans to repeat a similar intervention to disrupt or destroy the right to self-determination and political sovereignty of any other nation, offered by Representative Cole of Hartford and others. Please listen to the reading of the resolution by title only.
JRH 8, Joint Resolution condemning the January 3rd, 2026 U.S. military incursion in Venezuela and imploring that Venezuelan President Nicolas Maduro and his wife Celia Flores be released from U.S. custody, that all U.S. military forces recently deployed in the Caribbean Sea and the Eastern Pacific Ocean be withdrawn immediately, that Venezuelans be allowed to exercise their right to political self-determination on their own accord, and that the United States abandon any intentions or plans to repeat a similar intervention to disrupt or destroy the right to self-determination and political sovereignty of any other nation.
Now, this resolution has been read for the first time, and the same is treated as a bill and referred to the Committee on Government Operations and Military Affairs pursuant to House Rule 52. Now we have a joint Senate resolution to take up. JRS 37 is a joint resolution supporting, in solidarity with national and international ski organizations and numerous skiers across the globe, the introduction of a long overdue gender equality in Nordic combined Olympic competition, and urging that the International Olympic Committee only introduce new Olympic sports that practice gender equality. It was offered by Senators Morley and Baruth and was adopted on the part of the Senate. Please listen to the reading of the resolution by title only.
JRS 37, joint resolution supporting, in solidarity with national and international ski organizations and numerous skiers across the globe, the introduction of long overdue gender equality in Nordic combined Olympic competition, and urging that the International Olympic Committee only introduce new Olympic sports that practice gender equality.
Now, this resolution has been read for the first time, and the same is treated as a bill and referred to the Committee on Commerce and Economic Development pursuant to House Rule 52. And finally, JRS 39 is a joint resolution relating to weekend adjournment on February 6, 2026. It was offered by Senator Baruth and was read and adopted on the part of the Senate. Please listen to the reading of the resolution.
Resolved by the Senate and House of Representatives that when the two houses adjourn on Friday, February 6, 2026, it be to meet again no later than Tuesday, February 10th, 2026.
Now you've heard the reading of the resolution, and the question is, shall the House adopt the resolution in concurrence? Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and the resolution is adopted in concurrence. Are there any announcements? Member from Fairfax.
Thank you, Madam Speaker. As many of you know, tomorrow is Outdoor Recreation Day. The Caucus for Vermont's Economy will be hosting an outdoor recreation business listening session. It's going to be at 8 a.m. in room 11. This will be what we are hopeful of being one of many business listening sessions. So would love to just invite you all to come listen, hopefully ask some questions and just connect with constituents.
Member from Shaftesbury.
Madam Speaker, it's Wednesday, which means tonight is Farmers' Night. And tonight's program is a little bit different. It's not music. The title is Stories from the Woods. It's a curated story hour featuring 6 different stories. It's going to be hosted jointly by the Department of Forest Parks and Recreation and the Department of Fish and Wildlife. Please join us at 7:30.
Are there any further announcements? Member from Brattleboro.
Thank you, Madam Speaker. The Climate Solutions Caucus will meet tomorrow at noon in room 10. We will have pizza. We have a very exciting program tomorrow. The esteemed Pew Charitable Trust members will be here. They're bringing staff members who have traveled to share their expertise on issues related to infrastructure, financing, and deferred maintenance. They have a tailored presentation on disaster and climate budgeting principles that will also cover issues relating to public infrastructure. Hope you can join us for this important conversation. Thank you.
Are there any further announcements? Member from Waitsfield.
Thank you, Madam Speaker. Tomorrow at 4:30 in room 11, we will be hosting an education reform discussion. This is for all members of the body and really intended to bring members who are not in Ways and Means and education kind of up to speed on the conversations regarding education reform. And this is intended to be the first in a series of meetings. We will keep it to 1 hour. It's in room 11. Everyone is welcome.
Are there any further announcements? Seeing none. Orders of the day. Members, we will begin with House Bill 541, which is an act relating to interference with voters and election officials. Please listen to the third reading of the bill.
H 541, an act relating to interference with voters and election officials.
The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have passed the bill. Up next is House Bill 5, which is an act relating to a hearsay exemption for a child under 16 years of age. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Essex Junction, Representative Dolan, will speak for the committee. Please listen to the second reading of the bill.
H 5, an act relating to a hearsay exception for a child under 16 years of age.
Member from Essex Junction.
Madam Speaker, H5, as amended by the House Judiciary Committee, extends Vermont's existing hearsay exception to include children who are 13 to 15 years of age when the child is a putative victim of abuse or sexual assault. Under current law, this age-specific exception applies only to children aged 12 and under. It is important to note that H5 does not create a new hearsay exception. Rather, it expands the age eligibility of an existing evidentiary rule that already applies in limited proceedings and under strict judicial oversight in Vermont. The purpose of the bill is to ensure courts may consider reliable out-of-court statements in cases involving adolescent victims of abuse, recognizing well-documented developmental and evidentiary challenges in these cases. At the same time, the bill preserves constitutional protections for defendants and long-standing safeguards within the rules of evidence. By extending the existing hearsay exception to children ages 13 to 15, H5 aligns Vermont law with decades of child development and brain science. While adolescents in this age group may appear more mature, research shows they remain developmentally vulnerable, particularly when navigating trauma, abuse, and power imbalances with adults. Requiring these youth to engage fully in legal processes designed primarily for adults without appropriate statutory accommodation can risk further harm and undermine the pursuit of justice. H5 provides that accommodation while protecting the rights of defendants through requiring rigorous judicial findings before any out-of-court statement may be admitted. I will now briefly review the bill as amended by House Judiciary. Members may find H5 as introduced on the House Judiciary webpage with the committee amendment reflected on page 357 of today's calendar. The bill contains two sections. Section 1 amends Rule 804A of the Vermont Rules of Evidence to apply to children under 16 years of age, rather than limiting the rule to children aged 12 and under. This section also reaffirms that the hearsay exception applies only in narrow and specified circumstances, including civil, criminal, or administrative proceedings in which the child is a putative victim of sexual assault or aggravated sexual assault, lewd or lascivious conduct, incest, abuse, neglect, or exploitation, and cruelty to a child involving serious bodily injury. The next allowable circumstance is juvenile delinquency proceedings involving acts that would constitute these offenses if committed by an adult. And the final exception applies in child in need of care or supervision, CHINS proceedings involving allegations of sexual abuse. Section 1 also preserves critical judicial safeguards. Before admitting statements under the hearsay exception, the court must specifically find that the statements relate directly to the alleged offense or abuse, The statements were not taken in preparation for litigation and in criminal or delinquency cases were made prior to the defendant's initial court appearance. The child or covered individual is available to testify in court or pursuant to Rule 807. And lastly, that the time, content, and circumstances of the statements are deemed trustworthy. Section 2 sets the effective date. The committee's sole amendment to the bill changes the effective date to July 1st, 2026. During committee, we heard testimony from a broad range of stakeholders, including representatives from the Office of Legislative Counsel, the Vermont Judiciary, the Attorney General's Office, the Defender General's Office, the Department for Children and Families, victim advocacy organizations, law enforcement, and legal service providers. This testimony informed the committee's careful consideration of both child protection and due process concerns. Madam Speaker, H5 reflects a thoughtful and balanced approach to supporting adolescent victims of sexual abuse while maintaining essential procedural protections. The bill was reported favorably out of House Judiciary on a vote of 10-0-1, and the committee respectfully asks the House to join us in supporting its passage.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, the final bill on our action calendar today is House Bill 626, which is an act relating to voyeurism and disclosure of sexually explicit images without consent. The bill was referred to the Committee on Judiciary, which recommends that the bill be amended as printed in today's calendar. The member from Pittsford, Representative Millay, will speak for the committee. Please listen to the second reading of the bill.
H626, an act relating to voyeurism and disclosure of sexually explicit images without consent.
Member from Pittsford.
Madam Speaker, H626 strengthens our state's criminal and civil responses to image-based abuse. The strike-all amendment can be found on page 357 of today's House calendar. Image-based abuse includes the creation, distribution, or threat to share explicit images of a person without their consent. This type of abuse has become increasingly common with advances in and access to technology. And as we know, once an image is shared online, it can spread instantly and be nearly impossible to remove. The consequences of this type of abuse are wide-ranging, impacting survivors' safety, reputation, relationships, job prospects, and physical and mental health. Tragically, image-based abuse disproportionately affects young people and can shape the rest of their lives. As technology advances, it is essential that our laws be updated to protect Vermonters in this new reality. H626 addresses three forms of this abuse: video voyeurism, which are images or recordings taken without a person's knowledge or consent in a private setting, such as a hidden camera in a restroom; non-consensual disclosure of explicit images, which are images that may or may not have been originally obtained with permission or later shared without permission. Vermont's statute on non-consensual disclosure encompasses what is often called revenge porn, as well as digitally altered or AI-generated explicit images. Sextortion, a form of sexual exploitation in which a perpetrator threatens to disclose a real or synthetic explicit image unless a victim complies with demands. This can occur in the context of domestic violence, trafficking, or online scams. The bill strengthens remedies in criminal and civil court for victims of video voyeurism. For the criminal remedies, the bill creates a separate subsection on voyeurism, including images or recordings. This allows video voyeurism crimes to have a different statute of limitations, which we'll discuss more later in this bill. For civil remedies, H626 allows a harmed victim to file a lawsuit against a perpetrator who displays or discloses an image of voyeurism, and they may do so at any time, meaning there is no statute of limitations. The bill allows victims of non-consensual disclosure of explicit images to have access to the same civil remedies as victims of voyeurism. The bill also clarifies that a diagnosis of a trauma-related disorder, such as PTSD, meets the requirement of actual injury in a civil claim filed by a victim of voyeurism. This provision is informed by a 2025 Vermont Supreme Court decision, Kilbourne v. Simmon, involving harm caused by video voyeurism. In a concurring majority opinion, 2 justices emphasized that Vermont tort law has not kept pace with our understanding of PTSD and psychological trauma. They urged the development of this area of tort law to bring us closer to parity, ensuring that those harmed psychologically as well as physically are heard and compensated. I'll now go through the first 2 sections of the bill before yielding to the member from Williston to cover the other 3 sections. Section 1 pertains to voyeurism. Subsection A adds a definition of harm. This is needed because the term is used in subsection K. Subsection B rearranges the statute to separate unlawful intentional viewing from unlawful intentional photographing, filming, or recording for purposes of extending the statute of limitations for photographing, filming, or recording in Section 4. Substantively, the offenses in this section remain the same and amendments are technical. Subsection K establishes a private right of action against a defendant who intentionally displays or discloses to a third party an image recorded in violation of the statute and the display or disclosure causes the plaintiff harm. Subdivision K3 allows a plaintiff to recover damages for disorder resulting from trauma in a negligence claim under this statute. Currently, case law limits recovery for emotional harm in such actions. Subdivision K4 permits retroactive application of the statute of limitations for bringing an action under subsection K. Section 2, disclosure of sexually explicit materials without consent. Subsection B removes the words threaten or coerce because the committee created a new crime of sexual extortion in Section 3 of the bill. Subdivision B2 just moves the language from B1 to B2. And subsection E, subdivisions 3 and 4, mirrors the language in subsection 2605K regarding recovery for disorder resulting from trauma in a negligence claim and applies the statute of limitations retroactively. I'll now yield to the member from Williston.
The member from Pittsburgh yields to the member from Williston.
Picking up at Section 3, Section 3 establishes the crime of sexual extortion, also called sextortion, using definitions that are already used elsewhere in statute. Subsection B prohibits a person from knowingly threatening to disclose a visual image of an identifiable person who is nude or engaged in sexual conduct without that person's consent and with the intent to compel the person to engage in conduct against that person's will or to refrain from engaging in any conduct in which the person has a legal right to engage. Subsection C prohibits a person from knowingly threatening another person with the intent to compel that person to produce nude visual images, images of sexual conduct, or to engage in sexual conduct. Subsection D establishes the following penalties for a violation of the statute. A 3-year felony if the victim of the offense is 18 years of age or older. This is the same penalty as Vermont's extortion statute. A 10-year felony if the victim of the offense is under 18 years of age. A 15-year felony if serious bodily injury or death results from a violation of the statute. Subsections E and F provide limited immunity from prosecution for violating laws related to disseminating indecent material for a person who reports to law enforcement that they are a victim of sexual extortion. We heard testimony that this may help encourage victims to report without fear of getting into trouble for sending the nude images in the first place. Section 4 addresses the criminal statute of limitations. H626 extends the statute of limitations for voyeurism involving photographing, filming, or recording, voyeurism involving disclosure of those recordings or images, disclosure of sexually explicit images without consent, and sextortion to 40 years after the commission of the crime. This shift aligns with how crimes involving sexually explicit images actually unfold and provides victims with the option to pursue justice in criminal court. Section 5 contains the effective date, July 1, 2026, and a note that the bill will be retitled to an act relating to sexual extortion, voyeurism, and disclosure of sexually explicit images without consent in order to more accurately reflect its content. Madam Speaker, in 2012, 2 Vermont teenagers were asked to participate in a commercial shoot for a local cable access station. One of the girls knew and trusted the man who invited them. He was her college professor, so the girls agreed. What they did not know, and would not find out until 6 years later, was that the man had set up cameras in a makeshift changing room that he then directed the girls to use. He recorded them, one 19 years old, the other 17 at the time, in various states of undress, and uploaded that recording to a pornography website where it was viewed millions of times. When these 2 young women, sisters, learned through a friend that the video existed and was available on a porn site, there was nothing law enforcement or prosecutors could do to hold the man criminally accountable. Though voyeurism is a crime in Vermont, the statute of limitations had run out. In 2021, a 15-year-old boy, just a few hours from here, in Canton, New York, was contacted through Facebook Messenger by a person claiming to be a female peer. Over the course of a few short hours, the stranger befriended this teenager and eventually convinced him to send her nude images of himself. As soon as the photos were sent, the tone of these messages changed dramatically, and the person demanded money in order to keep the photos private. If the teen did not pay what was asked, the girl said she would send the nudes to everyone he knew. Caught in what seemed like a truly impossible situation, this young person ended his life. The person demanding money was not a teenage girl, but a sextortionist located on a different continent. This story repeats itself over and over and over again. Our committee heard testimony that stories just like this play out in Vermont on a weekly basis. Mercifully, they do not always end in suicide, but the harm can still last forever. I share these real-life examples to emphasize just how vital it is that we pass laws to address the rising risk of harm caused by advances in and access to technology. H626 is one step of many that we must take, but it is an important one. Our committee heard testimony from a long list of witnesses that I have available here for viewing, and our committee vote was 10-0-1. We ask for the body's support.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Member from Northfield.
Madam Speaker, I think this is a very important bill with important issues it's addressing. I do have some questions for clarification on a few pieces and also one area of concern that I want to raise. So, Madam Speaker, if I may start by interrogating the member from Pittsford.
The member from Pittsford is interrogated.
Madam Speaker, it appears that the only really new language rather than reorganization, if I'm reading it correctly, is that when it's discussing unlawful viewing and photography and so forth, it previously identifies in a place where the person would have a reasonable expectation of privacy, and it's adding under circumstances in which the person has an expectation of privacy. And I'm just wondering if the member could explain the distinction and maybe what an example would be of a circumstance that was not related to a place with a reasonable expectation of privacy.
Madam Speaker, I'm going to yield to the member for Williston.
The member from Pittsburgh yields to the member from Williston.
Thank you, Madam Speaker, and thank you, member, for the question. I would use as an example the circumstances that led to the case that I described. The sisters in that case were in a place where it was really the circumstances under which they found themselves, where they should have had a reasonable expectation of privacy because they were in a changing room.
So, Madam Speaker, that would not be considered a place where the person would have a reasonable expectation of privacy if they're in a changing room?
I'm sorry, member, could you repeat the question?
Madam Speaker, is the member saying that a changing room would not be a place where the person has a reasonable expectation of privacy?
I might ask for a brief recess to consult with Legislative Counsel.
The House will stand in recess for a couple minutes. Will the House please come to order and members kindly take their seats? Member from Williston.
Thank you for the recess. So I was reminded of a wonderful example providing illuminating the distinction. So picture a large open changing room at a department store, for example, where I wouldn't have a reasonable expectation of, that someone would be photographing me under the circumstance that I'm changing in and out of clothing. And place and circumstance are both defined earlier in the bill. I can, under Section 1, 2605, voyeurism, circumstances in which a person has a reasonable expectation of privacy, if I may quote from the statute, means circumstances in which a reasonable person would believe that the person's intimate areas would not be visible to the public, regardless of whether that person is in a public or a private area.
I thank the member, Madam Speaker, for that clarification. The second area is just getting a little clarity or making sure I wasn't missing the one or two pieces I did see. The distinction between disclosure under this current section, which is E, subsection E, and disclosure under section 2606, B1, which is on page 361. So both of them are about disclosure of images that were taken, but we have two separate statutes. And it appears to me that a key difference is that the first one on page 359 would only apply to the person who took the recording or the photograph, And the second one applies to anyone who may have possession of it and who discloses it to someone else. Is that correct, or is there actually a different substantive distinction?
Could the member direct me to the second reference? I'm looking at 3.
So on page 359, the middle of the page this is the offense of display or disclosure to a third party. And on page, beginning on page 361, the title is disclosure without consent. Of course, both of them are without consent. So going down to B1, no person shall knowingly disclose a visual image. And, there's a little bit of language that's different in each, but I'm just wondering substantively if, why there are these two pieces of statute that seem to cover the same basic offense.
Well, I would note that the definition can be found in 2606A1, which you... Sorry. Yeah, so as you're pointing to, as the member points to, disclose includes transfer, publish, distribute, exhibit, or reproduce. So as used in 2606, that is the definition of disclose or disclosure.
Thank you, Madam Speaker. But as applied to page, the earlier statute, which is section 2605, again, it seems very similar. It's talking about disclosure of a photograph, filming, or recorded, which would also mean reproducing. They seem like they overlap an awful lot, and I'm wondering if there was an intentional decision to not sort of combine them since they're overlapping and so similar.
I am going to say that we did intentionally break out, we divided up the voyeurism statute a bit so that we could apply different statutes of limitation based on the nature of the type of voyeurism. And so because of that breaking apart, we are using the word disclose a couple of different times, but there was no intent to, no intent to break them out for, intent, hold on one second. We're employing the plain language meaning. The difference between 2605 and 2606 is that 2605 is a picture without consent, and 2606, consent may have been given initially to take the photograph or produce the photograph, but not to disclose. There was no permission to disclose. So the intent to harm is what's required for this crime in 2606, but it is not required in 2605.
Thank you, Madam Speaker. I guess that's helpful. They both do say without the person's consent, so that appears to be the same. Thank you. I think it makes it a very confusing construct. But so the third question I had actually sort of relates in terms of the differences. the other major difference seems to be that what might colloquially referred to as, someone's private parts in terms of what type of disclosure might be. And on page 2605, I'm sorry, on page 359, section 2605, intimate area means naked or undergarment-clad genitals, pubic area, buttocks, or female breast of a person, which is significantly broader than for the disclosure under 2606, which is on page 361, where nude is very narrow and very specific to, I think, what people would agree are the most private areas. Was that discussed? Was that an intentional keeping the same definitions in those different places? Because I realize it's a different reporter of the bill, but the new section on sexual extortion also uses the meaning, the nude from section 2606 rather than intimate areas. So I'm just wondering if that was intentional, why that was, or not intentional.
If I am understanding correctly, the answer is yes, it was intentional, because 2605 is intended to, and was crafted originally really to capture the case of what we used to call a peeping Tom, peering into somebody's window, and that person, peeping into your window and into a person's window, and they're wearing their underwear or undergarments. And so it is capturing that behavior that might include somewhat less intimate, by some measure, state of being.
Thank you for clarifying that. And yet I look at it, and as that part of the statute is now outlined, it also is talking about disclosure, and it has actually a more significant penalty in terms of length of imprisonment and fine, and yet it includes a broader definition, which people might think is a less severe invasion of privacy. Was that discussed at all, or?
Madam Speaker, are you referring to the penalties for voyeurism in section 2605 or 2606?
Well, both. The one for on page 360, the penalty for disclosing to a third party an image in violation, which means the intimate area definition, is not more than 5 years or more than $5,000. But for the second section, switch back to that page, on page 361, but also the definition that's used for sextortion, both use the much narrower definition, and they would seem to be, I'm just wondering if that was a conscious division, because again, it seems to make the whole construct of the statute really confusing.
The committee discussed penalties quite extensively, and we were very deliberate in crafting or including stricter penalties for violations that include a lack of consent, images, initially created without consent, but then you get to images that could have been created with consent and then shared without consent. And so the penalty increases for sharing those images without consent, regardless of whether they were created initially with consent or not. And then, as you see, we took into account the age of the victim.
I thank the member. I want to, in terms of that different definition of the area that one wants to keep private, and because the first one, page 358, for section 2505, is the much broader one. I was wondering about the use of, and I recognize this is the existing law, the existing definition, but there is a change now in the ramifications of a violation. So I'm wondering about the inclusion of undergarment clad, which there doesn't appear to be a definition of. Was the issue of a definition for that discussed?
No.
Well, Madam Speaker, what would the member's interpretation be of undergarment clad?
The member's interpretation would be a body with undergarments on it.
Okay. Did the committee have a discussion about degrees of invasion of privacy, depending on whether a person was not clothed at all or undergarment clad?
No.
Would the member be surprised to know that one of the, quote, commonly recognized undergarments is long johns?
No.
And so, Madam Speaker, the member would support the idea of prison term and so forth for disclosing a picture of someone in their long johns.
The member would support the idea of appropriate penalties for an incredible invasion of privacy, regardless of whether there are undergarments involved or not.
I thank the member. Some of my other questions deal with the criminal prosecution, and I believe that was, if I may interrogate the member from Williston.
The member from Williston is interrogated.
Madam Speaker, I was looking at the various categories, which are all, although one part's amended, they're all included, I think because of some technical corrections, but helpfully they're all there in section 4 on page 364. And essentially when we look at categories of limits on prosecution, the statute of limitations, we've got 3 years is sort of the base level, the default. Any misdemeanor or felony, unless otherwise specified, is a 3-year statute of limitations. And then we have 6 years, 11 years, and then we jump to 40 years, and then a small category of any time, like homicide. And as I look through them, we can see that the, let me get to that page that I just referenced. So we can see that the area where it's, there's any time at all is the most extreme: aggravated sexual assault, human trafficking, murder, manslaughter, so forth. And then 6 years, lewd and lascivious conduct, sexual abuse of a vulnerable adult, embezzlement, forgery, and so forth. When we go to, and I'm sorry, jumping to D, but in order of the length of the statute, it's 11 years for arson and first-degree aggravated domestic assault. When we look at the other existing categories for the 40-year statute of limitations, the first one is lewd and lascivious conduct for a child under 18, maiming, lewd and lascivious conduct with a child under another chapter. We continue with sexual exploitation of children, sexual exploitation of a vulnerable adult. And then we go to adding voyeurism involving photographing or filming, such as a person in their long johns. And then also disclosure or display, and disclosure without consent, and sexual extortion, sorry. And I'm just wondering if the committee had any discussion of proportionality in terms of the overall decisions of the legislature about how far back prosecutions should be allowed for various crimes.
The committee did have a fair bit of discussion about appropriate statutes of limitation and the sort of policy goal behind such statutes of limitation. And in the cases of voyeurism involving photographing, filming, or recording, voyeurism involving display or disclosure, disclosure of sexually explicit images without consent, and sexual extortion, one of the main sort of factual elements that we discussed was the fact that these images, the creation of the images, that the creation may not be discovered for quite some time, and the forever nature of those images, especially once there is disclosure, for to the committee's mind, warranted inclusion in the 40-year statute of limitations.
Madam Speaker, if an image was disclosed at a sooner time, even though the photography or recording happened long before, wouldn't the statute of limitations toll from the time of the disclosure occurring? In other words, it being published or shared with someone else?
Not with this change. That was, not with this change to 40 years.
Thank you, Madam Speaker. Yes, I understand that, but under prior, if you did not have this extension, wouldn't disclosure of the images, if the disclosure of the images was within the past 10 years, say, and it was a 10-year statute of limitations, it wouldn't matter. You could still prosecute that even if the photo had been taken many years before. So the concern, I recognize the concern. I mean, images like this can end up being disclosed at any time. But this is not just addressing disclosure. Does that distinction make sense, Madam Speaker, in terms of the question?
It does. I believe we're discussing existing law. And the issue, part of the issue, one of the main issues being that the statute of limitations currently begins with the commission of the crime, not the discovery. So even if the disclosure happens close to the creation of the image, the victim may not know that it was disclosed until well after the existing statute of limitations has run out.
Madam Speaker, wouldn't disclosure be a repeated, each time it's disclosed would be an offense? So even the person discovering it, that disclosure would be within a much shorter statute of limitations unless it was disclosed years ago and the victim was aware of it and didn't bring a complaint. Wouldn't that be true, that the disclosure itself is a crime? So whenever a disclosure occurs, that would be what would trigger the statute of limitations?
We did hear testimony that date of disclosure can be very difficult to discern for that very reason, but we didn't hear any testimony that the discovery of the existence of the disclosure counted as a disclosure. So the victim is still, learning about the existence of the disclosure well after the disclosure and does not restart the clock with that information.
Thank you, Madam Speaker. That's very helpful. Madam Speaker, I want to discuss a little bit, not as interrogation, but just discuss the issue of ex post facto law and statutes of limitations. And they're different, but they can overlap or relate to one another. Ex post facto is talking about when something, if something was done when it was not illegal. In contrast, the statute of limitations is addressing when it was done that it was done when it was illegal. But the question is, how far back can a person be held culpable for it? And initially, when I looked at this statute, I was very concerned about whether the criminal aspects violated that concept of you can't, in fact, constitutionally go after someone for something they did when it wasn't illegal. And that concern was laid to rest when I talked it through with Legislative Counsel, because that constitutional principle holds, regardless of whether the statute explicitly says, well, it wouldn't actually go back 40 years for a specific crime if, in fact, it wasn't a crime at the time that you committed it. But I think the general concept is important. Why do we have that in the Constitution? And as the Vermont Supreme Court said just a few years ago, it's prohibiting Congress and the states from enacting a law which imposes a punishment for an act which was not punishable at the time it was committed. In other words, people are entitled to fair warning of the effect of those statutes and permit them to rely on their meaning. And going into that crossover with the statute of limitations, the Vermont Supreme Court also referenced just way back in 1991 that in a question about whether a statute of limitations, it was distinguishing among whether or not the extension of a statute of limitations violated it being ex post facto. And I think what it quoted from Judge Learned Hand, who said that this kind of a question turns upon how much violence is done to our instinctive feelings of justice and fair play. For the state to assure a person that he has become safe from its pursuit and thereafter to withdraw that assurance seems to most of us unfair and dishonest. So, the criminal aspect is protected from that concern. But when we talk about the civil aspect, if we're not talking about the Constitution, because that's about private actions, not state actions. But the sense of fairness, I think, raises the same issue in terms of how far back someone can prosecute or go after someone for instance, a youthful indiscretion. And particularly, what if it was not illegal at the time and it became illegal later? Our values as a society change about inappropriate behavior, and we can look back and say, we can see now how severely inappropriate it was. But at that time, we didn't consider it that. We didn't pass a law against it. And yet we are now saying that this person who violated this core value of society as it is established now should be culpable under our current system of values rather than what was in place at the time that the action was taken. And when we look at the current civil law, which is not reproduced the way the criminal law was, but we look at civil law and the current statute of limitations, 6 years is actually the default amount of time for bringing a civil action. And most of 12 VSA 511, which looks at statute of limitations, actually are when they shorten it, you even have less time, and that's for medical malpractice. And then, interestingly enough, for some fairly significant things, it's only 3 years rather than 6 for assault and battery, for false imprisonment, and for slander and libel. Don't know why those were picked out, and nothing else in terms of criminal actions. But there's only one in statute, which was recently enacted by this body. There's only one, and that is for sexual or physical abuse of a child, something that clearly was never legal to abuse a child. And we're adding today, or proposing to add, not just something about a child, but adding disclosure of images without consent to that level of not quite any time, but 40 years. And I would note, Madam Speaker, that the interesting thing is that in 12 VSA, which is court procedures, when we passed that statute changing the statute of limitations for child abuse and child sexual abuse, we placed a long section explaining that in the law on statute of limitations for bringing civil actions. And I'm not sure, I mean, I guess I do have a brief further question, and this would be, I think, for the member from Pittsford. In terms of that decision to say that it can be at any time at all for these new offenses being added, did I miss any statutes other than child sexual abuse and child abuse that we currently have no statute of limitations on how long ago it might have occurred?
The member from Pittsford is interrogated.
I would need to take a recess.
The House will stand in recess for 2 minutes. Will the House please come to order and members kindly take their seats? Will the House please come to order? Member from Pittsford.
Thank you, Madam Speaker. We'd have to do a title statute search, and we could get back to the member before the third reading.
Thank you, Madam Speaker. I guess that really leads pretty directly to my next question, which is, given that this section of statute identifies the other civil law areas for statutes of limitation, and given that we added specifically the one about child abuse and child sexual abuse, why wouldn't we also include this new change in a statute of limitation in one place so we didn't have to search the entire statutes to look for where there might be others? Was there a reason to not do that, or?
Madam Speaker, I don't remember us discussing a reason for doing that.
Thank you. I think my final question, and it is my final one, actually goes to the member from Williston because it's about the extortion section.
The member from Williston is interrogated.
Madam Speaker, this is just another question about sort of consistency in how we're doing things in the statute. And the new civil actions that are raised in other parts, was there any particular reason why a civil action for sexual extortation, I don't know why I can't get extortion down, why a civil action was not also included for a victim of sexual extortion?
The statute, or the proposed statute as written, does provide a civil remedy for victims of sextortion as well.
I thank the member. I will have to relook because I sort of hunted it down and didn't spot it, but I trust that it's there. Thank you, Madam Speaker. I really think this is an important bill, and I want to see it move forward. I will be voting for it today, but I will also be offering a few amendments that I think will bring it more in line with maybe where it should be before third reading. Thank you.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, that completes the orders of the day. Are there any announcements? Are there any announcements? Seeing, member from Burlington.
Madam Speaker, tomorrow night, the Sergeant at Arms and I are hosting a Breads and Spreads event in the cafeteria. I'll send out a reminder, but I just wanted to remind people tonight it's not too late to sign up to bring something. Thank you.
Are there any further announcements? Seeing none. Member from Poultney, can you please offer us a motion to adjourn until Thursday, February 5th at 3:30 p.m.?
Madam Speaker, I make a motion this body stand in adjournment until Thursday, February 5th, 2026 at 3:30 p.m.
You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and this body stands in adjournment until tomorrow at 3:30 p.m.